Okay, so I will just repeat this. Property with title, you can create a charge as per national land code, and property without title, you can create a assignment as per contract law. And we mentioned so many times. Registration conveys indisability. Indisability means cannot be challenged or set aside, and good against all other competing claims. As long as you have registered, you have indisability. This is under the law here. Don't need to memorize the laws, that's fine. Effective date of registration is the time of day entered the time and date in the presentation book maintained by the Registrar of Land Titles. This is why we emphasize ESR. Execute between charger and chargee. Some terms you need to know. Charger is the landowner. Chargee is the bank. Charger is the landowner. Chargee is the bank. Then you go for registration. Once you registration, you have legal interest. You have and then this one you write down, you have perfected security interest. You can write that down. Perfected. Is execution but not registered sufficient grounds? The answer is absolutely not, because your rights will be lost due to these other reasons here. And if the loan is already dispersed, you're definitely screwed. Can you do a charge on a property with no title? The answer is no. What can you do? LACA. Here, you can write down LACA. LACA. Loan agreement cum assignment. Which is more preferable? The charge, but you have to wait for the title issue before you can create a charge. And of course, to facilitate charge creation, the assignee banks requires developer to undertake to forward to the bank the government title when it's free of encumbrances, together with registrable memorandum of transfer. If you are a house buyer, why should you lodge a private caveat immediately upon signing the sales and purchase agreement? Because you want to prevent the vendor from reselling the property to another person, especially if the other person offered a higher price. Example of that would be, if you don't lodge the private caveat, they can transfer to another person. So what is private caveat? Private caveat means no dealing, no transfer, no charge. The only thing you can do is sue for breach of contract. Now here, indisability I mentioned earlier, okay, it's not absolute. There are 4 exceptions to this. This one came up in exam I heard in September. The 4 exceptions to indisability FMFU. It stands for fraud, misrepresentation, forgery of instrument, and unlawfully acquired. So you can write that down here. FMFU. Fraud, misrepresentation, forgery of instrument, and unlawfully acquired. Based on this, only bona fide purchaser who has provided in consideration shall continue to enjoy benefits of indisability. Let's recap. What does bona fide mean? We learned yesterday. Bona fide means what? Forgot, is it? Patah hatinya. Ayo. Patah hati. I'll type again, Bona fide means, you must memorize this, yeah? Genuine, in good faith. Yeah, you have to know this. Okay? Let's see. What does consideration mean? Something of
Value.
And what does indivisibility mean?
Cannot challenge.
Can't be challenged.
Not be challenged. So you see, Hafiz, right? When you look at this paragraph, it means a genuine buyer who has paid for it, consideration, will still enjoy benefit of indisability, cannot be challenged, even if there's fraud. Only a genuine buyer who has paid for it will still enjoy this. But no Hafiz, yeah? Protection is not extended to chargee. Is chargee the landowner or is chargee the bank?
The bank.
The bank. The charge will be voided in the event of fraud. Okay? That's why they say attestation must be done to minimize or eliminate forgery. So I need a favor. Let's see. Can I get let's see. Can I get Aiden, can you help take a picture? I know I wrote a lot of things just now. Can you take a picture and post in the WhatsApp group, please? Is that okay, Aiden? Okay. So what does bona fide mean? Bona fide means what? Genuine, in good faith. Yeah. So there's a lot of words you need to know. So what does it mean? Okay. I'll explain attestation later. Don't worry. I'll explain attestation later. This one I've already covered, so I won't repeat this again. Let's go straight to slide number 218. Okay, now you need to know what is Form 14A. So some forms you need to know for exam, yeah. So Form 14A is the MOT, Memorandum of Transfer. Form 16A is the MOC, charge. And 16A. Why I'm making this statement is because they will test this in exam. Form 19B is the private caveat. Okay. Okay, so one last beta, you can take a picture of what I wrote, 14A, 16A, and 19B. That one you need to know for exam. You need to know those definitions. And then this is assignment. Assignment is a contract in writing under contract law. They combine these three documents here: the deed of assignment, the loan agreement, the power of attorney, and they combine it to make your LACA. Next, we have a lien. A lien is another form of security to take over the land. It's the right to retain possession of the asset and form creditors' claim against it. It's only available when the land has been issued a title. You create what they call landholder's caveat. It's Form 19D. No party landholder's caveat is allowed, so it's a first party scenario. Advantage of lien is that it's fewer formalities compared to a charge. There's no stamp duty payable. So this is ideal for short-term advances. Disadvantage of lien is that from a practical point of view, there's no certainty on enforcement of the caveats. Okay, even judgment, it cannot be formally foreclosed. There could be delays or no certainty in securing judgment. And there could be, even if we get the delays, it may get delays on getting the order of sale. This slide you mark down will be exam topic. Exam topic, they'll ask you, what is the difference between private caveat and lien holder's caveat? Lien holder's caveat is recognized as security, no time limit, okay? Doesn't exist in Sabah and Sarawak laws, but private caveat is not a security. It expires automatically after 6 years, doesn't give you the right of power of sale to the caveator. So here for charge, the most important form of security, charge means the registered charge, is a security transaction whereby the land is pledged for repayment of debt. And because of event of default, the charge enable you to foreclose the property. Foreclose means you take it to auction. And these are the charges that they mentioned here. All right, let's see here. Say borrower is charger. Let's say Mark is borrower. Mark is charger. Is this first party or third party charge? Can you type your answer in the chat? Good. How about this one? Tribe Studio Sitting Bahad is borrower. Director of Tribe Studio Sitting Bahad is charger. Let me fix this. First or third party charge? Everyone type your answer, please.
Third party.
This one is clearly third party. Remember, the director is a separate legal entity from the borrower. Okay. Director is a separate legal entity from the borrower. Good. Can you create more than one legal charge? Okay, but here's another one. Can you create more than one legal charge
Yes.
on the same property? The answer is yes. Okay, good. Can, no issue there. Now, let's assume RHB is first legal charge. Borrower wants Maybank to be second legal charge. in order to get more loans from Maybank? Is it Charjo or Chargy that can give permission? Here's my question. Remember, Charjo is the landowner, Chargy is the bank. First Chargy. Okay, very good. First Chargy. Okay, good. Let's assume, okay, RHB has first legal charge. Okay, Maybank, just play along, has second legal charge. In the event of default, who gets the proceeds first during foreclosure? RHB. Good. Now, if RHB wants to foreclose, does it need Maybank consent? No. If Maybank wants to foreclose, does it need RHB's consent? I want you to look at the bottom right here. What does it say? Before you jump to conclusions.
No need consent.
No need consent. Okay. The answer is no. So, however, even if Maybank foreclose, who still gets proceeds first? Yeah, just to be clear. Even if Maybank foreclose, who still gets proceeds first? RHB. Very good. It's still RHB. So whether you accept a creation or subsequent charge is always the business decision. On the one hand, you retain the title, no other interest proceeds. The other hand, and this is where you have to negotiate accordingly, the charger may redeem the property and transfer to the other bank instead. This one is exam topic. They'll ask you what is the difference between principal and subsidiary charge. Principal is ad valorem. Subsidiary is nominal, $10. So key point here, the difference is the stamping. Especially when you have multiple titles, they will charge one of it will be MOC for ad valorem, the rest of it will be nominal. And this is what the stamping looks like. We'll spend time on this. Next part is while we do land search. I'm telling you guys, this is getting heavy, yeah? Your brains are probably flying right now, okay? So, just to share with you, this is an example of a land search. Just to give you an idea, this is an example of a land search. So, we have preliminary, you conduct it before S&P, and then you have to final. Check any flaws. Private can be done by himself. Officially will be preferred you apply to the registrar on any land and they'll issue a certificate of search. And for exam, you need to know these 7 reasons why we do the land search. Number 1, you check the ownership of the land, especially if we need to know if for first party or third party scenario. You check the particulars are correct. Third reason is some leasehold land in Peninsula Malaysia, they cannot be transferred to charge without consent of state authority or ruler of the state. So you have to get their permission. And fourth reason, you have to check the condition of title. For example, if you build like a factory zone in agricultural land, not only will you get fined, but you will be liable for forfeit as well. Slide 235, I want you guys to write this down. I want you to write down PC, RC, PO, and EC. Write this down. I'll go step by step here. These are what we call encumbrances. Private caveat PC is entered by anyone having a registrable interest in the land, and private caveat will remain in force for a period of 6 years. It may be shorter due to these reasons. This is the key point. The private caveat is entered by any person having registrable interest in the land. The register's caveat is entered by the register of land. I'll say the majority of the reason, just to keep it simple, 99% of the reason will be because of fraud. Okay, and there's what the other reason, maybe you didn't pay taxes or you protect the minors, etc. But majority of the reason is because of fraud. That's why you have register's caveat. This is the key point here. As long as the private caveat comes before the charge, you cannot charge. As long as the charge comes before the private caveat, you're okay. Okay. So as long as your charge is before private caveat, okay. With register's caveat, it doesn't matter. It will kill the private caveat. It will kill the charge, whether it comes in or not. Remember I said earlier, with a register's caveat, and they come in, your charge will become null and void because of fraud element. So with prohibitory order, this is for unsecured lending to satisfy judgment debt, and it's valid for 6 months, and then this is SSC charge. Now here we have Malay Reserve land. This is the general definition. Any dealing, disposal, or attempt to deal, dispose of Malay Reserve land shall be null and void. Now, in practical terms, the definition of Malay varies from state to state. The general term, this is the basic definition of Malay, and let me test your understanding. Can me, Long JG, buy Malay Reserve land? No, absolutely not. If you don't know this answer, I cannot help you, yeah? How about this? Look at the bottom left box. Look at the box here. The answer is no, cannot. Okay, Justin? Okay, Li Wen? Yeah? It has to be 100% pure. Okay? Every member, every shareholder must be Malay. Can JG be given power of attorney and act on Malay reserve land? The answer is also no. Also cannot. Okay. So the power of attorney cannot be given to a non-Malay to act on it. Customary land is for Malacca land, and native land is for Sabah and Sarawak. And what I sum up just now is land search. We also do another search. It's called insolvency search. And that's conducted with the DGI to check whether they're bankrupt. What's interesting in the book is they technically didn't prohibit a banker from charging the land, but they say it's a criminal offense because they're supposed to surrender the land to the DGI. Next part is documentation of charge. We have the Form 16A. That's the memorandum of charge here. And all these details must be correct, especially if you have a company, make sure the company registration number is here. No erasers, no blanco is allowed. Ballpoint pen also not allowed. Pencils definitely not allowed. You in execution, you can sign it or you can put a thumbprint. And the signature of the charger must be in permanent black or blue-black ink. Here is attestation. Attestation, it means it's the act of witnessing the signature of the charger is compulsory by law. Bank officer under national land code are not allowed to attest. Only the following officers can. Under national land code, magistrate, state director, land administrator, advocate solicitor, and notary public. In Sabah Sarawak will be different. Now, Malay reserve land, they're very strict. Only land administrator. Stamping is how much? They say 5 ringgit for every 1,000. The way you can remember for exam is 0.5% of the loan amount. 0.5% of the loan amount. And it must be paid within 30 days of execution. If not, you incur penalty. Penalty means the charge is impounded. That means it's inadmissible as evidence, depending on how long you're overdue. These are the penalties you have to pay. And here, this is the when have you presented for presentation. Once you made an entry in presentation book, that is conclusive evidence at the time of presentation of charge. So that is your ESR completion. The effective date of registration is the time and date of presentation entered in the presentation book. Those are the key terms that you need to know. Last point before we take our second break. What is a charge annexure? Charge annexure means the charges and charging rights or duty is in an express agreement. Because it either could be implied, but in an annexure, you put it in an express agreement. So all obligations, liabilities, rights, powers, and privilege are clearly stated in annexure. And they spelled out express conditions in the annexure, and you register with the charge. Note the annexure is not the same as the registered charge. Okay. Let's take a break now. I know that was very heavy, so I'm gonna put a slightly longer break. Make it 15. Make it a 15-minute because that was very technical. Yeah. We'll make it a full 15-minute break, and then I'll see you guys in 15 minutes.